You're listening to the Quint's podcast.
Stating that the centre can't get a free pass every time by just stating national security, the Supreme Court on 27 October appointed an external committee to investigate the allegations of unauthorized use of the Pegasus spyware on citizens. After weeks of back and forth between the centre, the petitioners, and the court on Pegasus, the Apex Court sharply noted in its order that the quote-unquote vague denial from the government is not sufficient, and that it had no option but to set up a panel to examine the allegations made by the petitioners. The court's stern observations on the issue comes after hearing a clutch of petitions which requested a probe into the allegations of the centre's use of Pegasus on over 142 Indian citizens. The revelations regarding the use of Pegasus were made after a consortium of media organizations around the world reported in July this year that prominent politicians like Congress leader Rahul Gandhi, 40 Indian journalists, and several private citizens were spied on and their phones were also hacked. However, the centre has to date refused to take a clear stand on whether it has purchased or even used the spyware. And given the centre's stonewalling on this issue, how significant are the observations made by the court? Will an expert committee be able to unearth the answers which the court has been unable to do so thus far? And what powers will this committee have? Joining me today to discuss the significance of the order and also what functions the expert committee will possess is Apar Gupta, the Executive Director of the Internet Freedom Foundation, and Gunjan Chawla, Program Director of Technology and National Security at the Centre for Communication Governance at NLU, Delhi. You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you, and I'm your host, Himmat. Before we move to the crux of the episode and understand the functions of the expert committee, it is important to note the strong observations made by the court. Here are just some of the highlights of the order. The order stated that, quote-unquote, every citizen has a reasonable right to privacy, choices, liberties, and freedom, and underlined that though, quote-unquote, there are restrictions on the right to privacy, they have to stand constitutional scrutiny. Concerns regarding freedom of the press in India were also raised by the court, stating that, quote-unquote, it is undeniable that under surveillance, it affects the right and the freedom of people and how it is exercised. It is also about the freedom of the press and the important role played by them. Such technology may have a chilling effect on the freedom of speech. The order also took special care in highlighting the lack of clarity that the centre has provided thus far in the case, and that it must prove and justify the concern of national security, adding that, quote-unquote, the mere invocation of national security by the state does not render the court a mute spectator. And finally, the court pertinently stated that given that there is no specific denial by the centre, it has, quote-unquote, no option but to accept the prima facie case made by the petitioners to examine the allegations made. According to Apar Gupta, the court observations are significant since they clearly lay out that the centre has been given ample opportunity to respond to the allegations. He dissects how the order highlights issues regarding right to privacy, freedom of the press, and national security.
So the court has gone through, and if you look at the structure of the judgment, it's quite fair. It first says what do the petitioners say, and then says what is the opportunity which has been provided to the union government. The union government has been provided multiple opportunities, as the order discloses, to place in forward an answer as to whether it procured Pegasus, how is it utilized, etc., etc. But only files what is called as a limited affidavit, and this is quoted within the judgment. The limited affidavit, as per the court's own words, is in quotes vague and omnibus. So by itself, it does not state any clear answer and merely annexes a statement made by the Honorable Minister for Electronics and IT as well as Railways and Telecom, Mr. Ashwini Vaishnaw, on the floor of the House in Lok Sabha and the Rajya Sabha. Secondly, the court gets into the national security argument as well, which is cited by the government to prevent filing a much more detailed affidavit and getting into the factual instances raised by parties, especially those who have been impacted. This includes independent journalists. For instance, IFF was representing Rupesh Kumar Singh and Ipsha Sakti, who are independent journalists in Jharkhand. and their phones were actually surveilled by Pegasus. So in their petitions, they have made certain allegations, also how it impacts their sources. Even with respect to this, the court says that it will impact a individual's right not only to privacy but also journalists for the respect to their freedom of speech and expression, their ability to do news gathering, and will cause a chilling effect. And then it juxtaposes the national security argument. And here the court is very, very clear. The court says in paragraph 49, national security cannot be the bugbear that the judiciary shies away from by virtue of its mere mentioning. Although this court should be circumspect in encroaching upon the domain of national security, no omnibus prohibition can be availed for against judicial review. End of quote. The court essentially is saying that if you're claiming national security and you're not providing details, you have to say which details you cannot provide. You have to give reasons for it. And hence, on the basis of the nature of the allegations raised, which are serious and the court observes are prima facie demonstrable as credible, the lack of any investigation by the government, and also the claim of national security not to provide any clear answers or factual submissions to the court goes on further and notes that it is constituting this committee.
As I stated earlier, the court has appointed an independent technical committee to probe allegations made by the petitioners. The court will be hearing the case again in 8 weeks to hear the results of the probe. Now, according to the order, the committee will be overseen by retired Judge R.V. Ravindran. He will be assisted by former IPS officer Alok Joshi and Dr. Sandeep Oberoi. They will also be joined by a technical subcommittee comprising of cybersecurity experts such as Dr. Naveen Kumar Chaudhary, who is a professor of cybersecurity and digital forensics and the Dean of National Forensic Sciences, University Gujarat, and Dr. Prabhavaran P., who is a professor at the School of Engineering at Amrita Vishwa Vidyapeeth, Kerala, and lastly, Dr. Ashwin Anil Gumaste, Institute Chair and Associate Professor of Computer Sciences and Engineering at IIT Mumbai. The court has now effectively ordered the committee to investigate 6 core points, which in short are whether Pegasus was in fact used on citizens, the list of victims of such a spyware attack, investigate the steps taken by the center so far, whether any central or state government or any governmental agency or person acquired the spyware and used it, and what legal grounds have they used the spyware on. The center has so far stonewalled all requests and in a limited affidavit claimed that all allegations are conjecture and are based on quote-unquote unsubstantiated media reports. It also reportedly used the specter of national security as a response whenever it has been prodded by the court. So, given how reluctant and obscure the center has been in the case so far, both in the court and in parliament, how effective will this independent panel be in bypassing governmental red tape? According to Apar Gupta, the committee at first glance does look well equipped to handle the investigation. However, he states that there is no clear direction in the SC order, and the absence of an accountability mechanism also throws up the question of what the final verdict of the investigation the public and especially the petitioners will receive.
So, according to me, the committee on first glance appears to be independent. It's headed by a well-respected former Supreme Court Judge, Justice R.V. Ravindran. It has technical members, so it will have the capacity and expertise as well, which are former ranking officers of the Indian Police Service like Alok Joshi or come from the domain of technical standardization and cybersecurity like Dr. Sandeep Oberoi, and also has a sub-technical committee comprising of various professors from the top faculties in India and institutions like the IITs. The questions also and the terms of reference framed by the Supreme Court, which is in para 61, go into these very particular questions which will need to be answered and will require the committee to, in fact, summon government witnesses, public officials for depositions. For instance, question number 3 is, and I quote, what steps action have been taken by the respondent, the Union in India, after reports were published in the year 2019 about hacking of WhatsApp accounts of Indian citizens using Pegasus suite of software? Question number 4, whether any Pegasus suite of software was acquired by the respondent, Union of India, or any state government or any central or state agency for use against the citizens of India. End of quote. So it's quite a natural progression, given the constitution of the committee, also the kind of terms of reference placed before it, that we can possibly expect clear answers, which is the very objective why it has been set up. However, as I said earlier, the proof is in the pudding. There is no clear direction in the order, and I think is one deficiency to be noted, that a copy of the report will also be examined by the court and then be made public. Hence, the report may just be submitted to the court, and the court, and whatever steps it takes upon them will only then become public. So I would say that we lack clarity as to what will be the next steps after the committee does submit its report, what will be the accountability mechanism, as well as what will be the level of transparency. So independent commentators as well as victims who will approach the court may obtain a copy and also provide further inputs.
We took this question to Gunjan Chawla as well, who is the Program Director of Technology and National Security at the Center for Communication Governance at National Law University. And according to her, the court order does state that the committee has a wide range of powers, especially to call upon any agency or person for statements or records. But she questions the extent to which this power can be used given the provisions of the Evidence Act of 1872.
Certainly, the court has gone to great lengths in putting down in black and white what are the questions that the committee needs to be looking at and what are their powers to do so. And I think one specific point that comes up from the committee's terms of reference is that the committee has the power to take statements and call for records from any authority or individual. Now, on the face of it, saying any authority or individual does give them a very wide discretion to call upon public officials to produce documents as and when they may be required to find out, to get to the logical conclusion of this fact-finding exercise. However, given that one of the questions that the committee is looking into is whether or not the spyware was acquired by government agencies, I think there are certain provisions in our regulatory provisions that may I would say, restrain the ability of not just the committee, but also the court itself to look at the kind of documents that may or may not exist in this context. I've previously written about this, and the general financial rules, which is the omnibus regulation that governs public procurements that are conducted by civilian authorities in the country, have explicit provisions that empower the government to undertake certain procurements secretly, or basically not publish these procurements out in the open if they deem it fit in the interest of national security. Now, notwithstanding the fact that this is the first time that the phrase national security has entered the vocabulary of the general financial regulations, which in itself is a huge issue, I think if the answer to this question of whether the government acquired the spyware is in the affirmative, certainly there are certain documents that exist somewhere which have been marked as non-public or secret and are not fit for disclosure. That brings us to evidentiary concerns that the court has been struggling with in the process of coming up with this order as well, right? Now, whether or not we like it, the kind of legal framework that we have is one that was framed by our colonizers to keep certain information completely out of the public domain. And our evidentiary rules kind of enable that kind of tendency. If we look at sections 123 and 124 of the Indian Evidence Act, which relate to official communications of the government or material that may have been disclosed to a public official in confidence, such material is explicitly prohibited from being produced in court as evidence unless the same public official who designated these documents as non-public agrees to their disclosure being in the larger public interest. So we may have gone through the process of going to the court and getting the right order, but I don't suppose that the word any authority or individual is going to be interpreted so widely that it exceeds the authority that courts themselves have in terms of what evidence they can and cannot ask to be produced before them. So it would be interesting to see how the committee works around this kind of a provision. Actually, that's not the right word. I wouldn't say how they work around it. I think a lot would depend on whether or not the committee can induce cooperation from the government in sharing necessary and relevant facts with them.
The Supreme Court's Steely order on Pegasus resonates with its statement from 13 September that there will mean no quote-unquote beating around the bush, and does give some direction towards a positive outcome in the coming weeks. But the question which still sticks out is whether the centre will relent and comply with the investigation. If you liked listening to this episode, please subscribe to The Big Story for episodic updates. We're available on Apple, Google Podcasts, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website, and for any feedback, please shoot an email to podcast@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.